Are you retired or about to be retired? One wrong checkbox can send your money to the wrong person. In the next 60 seconds, I'll share with you the 10 beneficiary mistakes that quietly disinherit families and the quick fixes so your money goes exactly where you intend. Hello, I'm Jason. I build retirement plans every week, and you'll want to stay till the end because the last three are those sneaky ones that oftentimes fall through the cracks. So, mistake number one is having no contingent beneficiaries. So, what do I mean when I say contingent beneficiaries? Well, with most retirement accounts, let's just say an IRA or a 401k, you have what's called primary beneficiaries that you typically list first. And oftentimes that's your spouse. Okay. So, list your spouse as primary beneficiary. If, God forbid, you both pass away at the same time, it would go to your contingent beneficiaries, the second level of beneficiaries. Now, a lot of times people will fill out primary beneficiaries, but they won't fill out contingent beneficiaries. So, what happens if you don't have any contingent beneficiaries listed? Well, there won't be anyone to lead this through. It could end up in probate, it could cause delays, additional court costs, and attorney's fees. So, what's the quick fix? You'll want to add contingent beneficiaries on all of your accounts. This can mean retirement accounts, brokerage accounts, life insurance policies, etc. Mistake number two is naming my estate. Now, if you just simply name my estate as your beneficiary, it feels simple, but it's really not. It can cause a lot of problems. You could end up in probate. Creditors could have a claim on your assets. And then also, in regards to retirement accounts, it could force taxable events or your heirs to pay taxes that could have otherwise possibly been avoided. So, what is the quick fix in this regard? Well, we want to name actual people or institutions, whether that is a church or a charity, a 501(c)(3, or if you go ahead and meet with a qualified estate planning attorney and you set up a trust, it may make sense to name the trust. I want to encourage you to click the link below and download our free Quick Start Estate Planning Guide. The first page of this guide is very, very simple. It's 3 steps. It tells you exactly how to know which accounts to call on, a script to use, and the proper questions to ask to make sure that you can get these beneficiaries in order. So I want to encourage you to click the link below, and we'd love to send you a free copy of that Quick Start Estate Planning Guide. All right, so mistake number three is not selecting per stirpes. All right, so what do I mean when I refer to per stirpes? Well, per stirpes is actually a Latin term that's used in the legal world that means by roots or by branch, and it's referring to kind of your heirs and who is in your bloodline. So let's use this simple diagram, okay? And let's just say you're generation one, okay? And then your kids are generation two, and then your grandkids are generation three. All right. Now, if your children, okay, have children, you may want to consider selecting per stirpes. And what does that mean? Let's just say you are the surviving spouse, okay? And you have a daughter and you have a son, but your son has two children. Your son has a son and a daughter. You may want to choose per stirpes on your son so that if you were to pass away, and let's just say you're leaving everything 50-50, half goes to your daughter, half goes to your son. But let's just say your son predeceases you. So that half that was supposed to go to your son, you'll most likely want to go to your grandchildren. Or if you do want it to go to your grandchildren, you'll want to do per stirpes designation. Now, there are a lot of things to consider whenever we are designating things per stirpes. So you'll want to speak to a qualified estate planning attorney to define, does this really apply in my situation? Mistake number four is the wrong trust named. An example of a name of a trust could be the Jane and John Doe Revocable Living Trust dated April 15th, 2005. Okay. It's a very specific name. And if you don't get that completely right, it can cause a lot of issues after you're gone. Another issue that we see in terms of the wrong trust named is if the wrong trust was drafted, if it's not a truly a pass-through trust, and it all has to do with the language inside of that trust. And why can this be an issue? Well, if the language is not correct, your family could end up paying taxes all in 1 year when they didn't intend to. They could pay more taxes than they wanted to pay, and you kind of lose some flexibility in terms of the distributions of that estate. So, what is the quick fix? Well, again, you'll want to talk to a qualified estate planning attorney, and you'll want to make sure that the trust language accounts for retirement accounts, and then also that the trust language accounts if you have anyone in your family that has special needs or you're leaving things to a minor. And that leads us to mistake number 5, which is special needs or minors that are named. If on your beneficiary form you list a person that has special needs or you list a person that is a minor, that can cause a lot of issues. All right, so what is the quick fix to try to avoid that? Well, you'll want to sit down with a qualified estate planning attorney because this may be one of those situations when it makes sense to have a trust or have a trust drafted because then you can have specific language and specific provisions for people with special needs and or minors. Then, once that trust is drafted and funded, you can name the trust as the beneficiary. You just want to make sure you use the right name, right? And sometimes people will have multiple trusts. So sometimes this trust is the beneficiary of this account, and this trust is the beneficiary of a different account. Mistake number 6 that we oftentimes see is when it revolves around 401k and spousal rights. Now, the issue that we sometimes see is let's just say you're married and you're kind of divvying up your estate and you say, you know what, I want my 401k to go to the grandkids. Okay. So you just name your grandkids as the beneficiaries of your 401k. Well, many 401ks have stipulations in them that the spouse, your spouse, has something called spousal rights. What that means is if you do not leave your 401k to them, they have to sign off on that so that you can leave it to someone else, whether that be children, grandchildren, a church, a charity, etc. So you don't want to just fill out a 401k beneficiary form and name someone other than your spouse without checking those specific guidelines of your 401k plan. Mistake number 7 that we oftentimes see revolves around something called HSAs or health savings accounts. So let's start with what is an HSA. An HSA is a health savings account where you can put money into a health savings account as long as you qualify per the guidelines to do so. And then that money can be invested and grow, grow, grow. And then you can use that money to pay for medical expenses tax free. So you put it in before taxes and you're able to pull it out tax free. It's a very, very powerful account. Now, most of the time, you'll want to consider naming your spouse as the beneficiary of your HSA. Because if you leave your children as the beneficiary or your grandchildren as the beneficiary of the HSA, the gains inside of that account will most oftentimes become taxable to them. Now, everybody's situation is different. You'll want to talk to your CPA or accountant in regards to passing on your HSA to someone other than your spouse. But we just want you to be aware. What is a quick fix? Like I said, talk to your CPA or accountant. Possibly name your spouse as the beneficiary, and then let whoever know is going to be the executor of your estate know that with that HSA, if someone other than your spouse is the beneficiary, there are some guidelines and there's some deadlines that you're going to want to be made aware of so you don't miss them. Mistake number 8 has to do with when you roll over certain IRAs or 401ks. Okay, so this mistake we see often is when people do not update after they roll over. So you were with your employer, you had a 401k and you rolled it to an IRA, or possibly you were in one IRA and you rolled it over to another IRA. Sometimes people believe that the beneficiaries follow the account, which typically is not true. Okay. Anytime you change an account, you'll want to update the beneficiaries. And again, you'll want to put primary beneficiaries and contingent beneficiaries on the beneficiary form. Because remember, if you don't update your beneficiary information, it is going to be left most likely open to probate because then the courts or a judge is going to have to decide what were your actual wishes because there's nothing in writing in terms of the beneficiary form to direct so. So, what's the quick fix? After every rollover or whenever you open up any account, make sure you update the beneficiaries and that they're aligned with your desires. Mistake number 9 has to do with divorces and people who remarry. Now, I can tell you this, there have been several times where we're sitting in our conference room with a client that was remarried, and we do our beneficiaries check just to make sure that everything is order and everything is in line with their wishes. And it has happened more times than I care to share when an ex spouse, a former spouse, is listed as a beneficiary. Now, you can only imagine this makes for a pretty awkward conversation. So, if you have been divorced or if you've gone forward and been remarried, you're going to want to update your beneficiary forms. And here's a misconception. Sometimes people believe, well, I updated my will, okay, so I'm good to go. Remember, contracts supersede wills, meaning whatever is listed, okay, in terms of your beneficiary, that is what that custodian is going to follow. They will not follow your will most of the time, okay? So we want to make sure the beneficiaries on file are up to date because we want to make sure your money goes to who you want it to. So, what is the quick fix here? Basically, if you have a divorce, or if you become remarried, or if there's a birth in the family, if there's a death in the family, if you move, any of these life estates, I highly, highly encourage you to do a beneficiary review. Now, if you're not working with a financial advisor, I would encourage you to put a date on the calendar so every year you're looking at these to make sure that they're correct. And our last mistake that we oftentimes see retirees make is when they do not have something called payable on death or transfer on death designations. Okay, so what do I mean by POD or payable on death or transfer on death, TOD designations? Most of the time, these have to do with bank accounts or certain types of brokerage accounts. A lot of times, they're non retirement accounts, okay? These types of accounts don't have primary beneficiary necessarily and contingent beneficiary. And so we need to define payable on death or transfer on death so that we make sure after we're gone, those accounts go to the correct people that we want them to. I do want to make one stipulation here in terms of payable on death. Payable on death, a lot of times, is used by banks, and banks don't have primary and contingent. A lot of times, if you list a group of people, everyone will get the same amount of shares. So if you list 4 people, they're each going to get 25%. That's not always the case, but it's something to consider whenever you do go to your brokerage firm, whenever you look at your bank accounts, CDs, money markets, all of those things. All of these non-retirement accounts, you'll want to ask that question, can I list primary and contingent? And if not, if it's one of those payable on death, you'll want to understand that most of the time, they'll all get equal shares, whoever you name. I hope this list of mistakes that we oftentimes see can help you and your family avoid any of those headaches or heartaches. And as a good homework item, I'd go ahead and download that Quick Start Estate Planning Guide in the link below so that you can start getting all of these things in order. And I want to encourage you to go ahead and click this video here where we go over the 5 reasons to retire as soon as you can.